Every time abortion comes up in Zimbabwe, the volume goes up. Some people say the law is too strict. Some say it is already doing too much. Others, they say just legalize it and move on. And before we even get into this conversation, I know what some people are thinking. But what about rape victims? What about risky pregnancies? What about girls who are too young? Those questions always come fast, and usually from people who have never actually checked what the law says. Because here's the funny part. We argue about abortion like the law is completely silent. Like Zimbabwe just woke up one day and said, hey, we have no rules, let's freestyle. Meanwhile, the law is sitting right there, written down, with conditions, with exceptions, with procedures. So before we talk about changing anything, it makes sense to understand what already exists. Zimbabwe's abortion law is found in the Termination of Pregnancy Act. It dates back to 1977, and it starts from restriction, not permission. Under this law, abortion is already allowed in specific situations. First of all, when a pregnancy threatens the woman's life. Secondly, when it risks permanent physical harm. Thirdly, when there is a serious risk of severe fetal impairment, and when the pregnancy results from unlawful intercourse. So yes, rape is accounted for. Risky pregnancies are already accounted for. Extreme situations are already recognized. So the law does not pretend that these realities do not exist. It just refuses to treat abortion as a casual solution. The structure of the law tells you exactly what it was trying to do. It acknowledges that there are circumstances where continuing a pregnancy would be unjust or dangerous, but it also draws boundaries. That is why abortion under this law comes with safeguards, medical certifications, designated institutions, judicial involvement in certain cases. Safeguards. Those steps are not accidental. They exist to slow down the process, to make sure the decision is serious, to prevent pressure or coercion or convenience from driving outcomes. Over time, pressure has built around how narrowly some parts of the law were interpreted. Not because the law ignored extreme cases, no, but because some definitions were too tight. Questions came up around minors, around sexual violence within marriage, around whether the law was being applied consistently. Those questions did not challenge the existence of the law. They challenged how its edges were drawn. In November 2024, the High Court of Harare stepped into one of those pressure points in Women in Law in Southern Africa in Talent Forget versus Minister of Health and Childcare and others. It looked at how unlawful intercourse was defined. The court held that excluding marital rape and failing to clearly include pregnancies involving minors raised constitutional concerns. This did not remove restrictions. It did not introduce abortion on demand. It clarified who falls within an existing exception. It adjusted the margins, not the foundation. Now the conversation has moved from the National Assembly to the Senate. And this is where people need to be careful, because once the discussions shift from how do we apply existing exceptions fairly to let's open it up more broadly, the nature of the law changes. Safeguards start to weaken, seriousness starts to fade, and consequences appear later, not immediately. The existing law already recognizes hardship, danger, and injustice. It already makes space for extreme cases. The real question is not whether abortion exists in Zimbabwean law, because it does. The real question is whether expanding it further improves protection or removes the necessary restraint. So before you rush to rewrite the law, it might be actually worth reading it. Because Zimbabwe's abortion debate is not about silence. It is about boundaries and what a society chooses to treat as exceptional rather than normal. That's the law, and that's life. This is Law in Life with Kuda.